have lots to cover today. I'm going to ask if the State Bar would take roll and announce whether or not there's a quorum.
Okay, so I can go ahead and do that. Chair Susan Bakshian,
Present.
Don Smythe,
Present.
Christopher Don,
Present.
Donald Scotton,
Present.
Nidia Dueñez,
Present.
Devin Kenyon,
Present.
Jennifer Mnuchin. We have a quorum.
Thank you. A couple of quick announcements. These will be reminders for those of you who are continuing your service, and some quick announcements about the Law School Council in general for those of you who are new to beginning your service. The Law School Council typically meets twice a year. Obviously, we did miss the April meeting this year due to the pandemic, but there were many participation meetings as we quickly pivoted to an online exam and there was a contribution from lots of the law schools during that time, though the Law School Council remains one of the primary ways for the bar to take in comments and receive questions and information from law schools. So those general participation meetings sort of filled the gap for us by that missed April meeting during the transition to remote exams. This is a 7-member board comprised of folks from ABA schools, generally deans or administrators. Applications are typically accepted in June for 3-year terms, and members are appointed by the chair and vice chair of the Committee of Bar Examiners. And finally, the last announcement, the State Bar will both request and receive feedback at these meetings, and that is its purpose from this committee. So we will have lots of opportunity for you to do that in today's meeting. I want to specifically start by welcoming our 3 new members. I'll just point them out quickly. We have Devin Kenyon from Santa Clara Law School, Christopher Idon, help me, Christopher, I'm going to get that right.
Sure. No, it's E-Day, Don.
E-Day, Don?
Yeah.
Okay.
Thanks.
I'm going to practice. From UC Davis, and also Nidia Dueñez from Southwestern. And Nidia, I'm getting yours wrong as well. So help me until I correct them. I'll tell you what I tell my students. Correct me until I say it correctly, because otherwise I'm going to learn it wrong.
Sure, it's Dueñez. Thank you.
Dueñez, thank you. And I'd also like to thank and introduce our 4 directors and analysts here from the State Bar today. We have Amy Nunez, who is the Director, Office of Admissions. We have Audrey Ching, Director, Office of Admissions. We have Natalie Leonard, who's a Principal Program Analyst and staff to this committee. And we have Grant Wiekesser, the Program Analyst in the Educational Standards Division. And in our audience today, I want to recognize particularly Paul Kramer, who is Chair of Educational Standards for the Committee of Bar Examiners. So I'd like to thank everybody who is here today. And I'd like to start by, I don't believe we have any I'm not sure if we do have members who want to give public comment, but we're going to do that first today. So do we have any members of the public who would wish to make a public comment? If we do, I'd like you to raise your hand using any of the Zoom functions.
I don't see any raised hands.
Okay, having no public comment, we will instead move directly to our discussion items for today. We have a very full agenda, so a couple of quick things. Just to remind you, this is the first of 3 meetings. We have 2 meetings next week, the Registrar's meeting and the Law School Assembly, both of which on December 10th. The Registrar's meeting from 9:30 to 11:30, and also on December 10th, the Law School Assembly from 1 to 4. Today's meeting is a good opportunity to make sure that anything that would be helpful to address in either of those meetings is talked about and mentioned, and we can get started on that today. So this should be a good way to expand those discussions later next week. Those meetings are a little bit different than today's. Those are open to all schools. They are for registered, unaccredited, accredited, and ABA approved law schools. So those will be all law school meetings next week. Today, we are going to have staff reports on lots of key developments, including, of course, the most obvious topics of provisional licensing and the bar exam. We are also going to have the State Bar staff today will be noting any questions, both answered and unanswered, and we'll have it will help us create priorities for next week's meetings. So if we don't have any initial questions before we get started, we can go ahead and begin with our staff reports. Anything first? All right, folks, let's go ahead and I'll ask Amy Nunez to begin with the provisional law licensing program.
Amy is on mute.
Yes, it helps not to be on mute. Sorry about that. So good morning, everyone. I'm going to report on the provisional licensing program, and I'll start with a background. As many of you may be aware, in July of this year, the California Supreme Court directed the state bar to develop and implement a temporary supervised provisional licensure program. That is a limited license to practice California law under the supervision of a licensed attorney. What the program does is allow 2020 law school graduates to practice law as provisionally licensed lawyers under the supervision of a fully licensed lawyer. Applicants must meet most of the licensing requirements, and the exceptions are bar passage, MPRE passage, and moral character clearance. And the supervising lawyer must also agree to assume professional responsibility over the work of the provisionally licensed lawyers. The program is scheduled to terminate in June 1st, 2022, unless extended by the court. And essentially, provisionally licensed lawyers are able to engage in all activities of a fully licensed lawyer, subject to certain restrictions. Now, in terms of eligibility, applicants who are 2020 law school graduates, and that is specifically those who graduated between December 2019 and December 2020, are eligible. They must meet the following requirements for eligibility. They have to have submitted a complete moral character application. So the application itself does not have to have reached a confirmation of either denial or a clearance, but has to have been submitted. If an applicant has not passed the MPRE prior to enrollment in the program, they must take the 4 hours of legal ethics training that's included in the 10-hour new attorney training within the first 30 days that the training is made available. Applicants also cannot have outstanding child support arrears or outstanding unpaid admissions fees. And applicants must have an employment offer, a conditional employment offer, a volunteer opportunity or conditional volunteer opportunity lined up when applying. As for the requirements for a supervising attorney, a supervising lawyer must have practiced law for at least 4 years in any US jurisdiction, but have actively practiced law in California for at least 2 years immediately preceding the time of supervision. They must also exercise competence in the area of California law in which they're supervising the PLL, and be a licensee in good standing with the State Bar of California. There are a few considerations if somebody meets those eligibility criteria as a supervising lawyer. They have to work for the same firm for which the provisionally licensed lawyer will be employed or volunteering at. And they must also, and I mentioned this already, agree to assume professional responsibility for any of the work that the PLL performs. And we also have a disclosure that needs to be submitted in writing is part of the application process. And it's a declaration that serves to confirm that the applicant will be employed or volunteer at the firm or organization that the supervising lawyer works at, and that they have an office that's located in California. Also, that the nature of the employment conforms with the requirements of the rule, whether the employment is paid or unpaid, and that the supervising lawyer meets eligibility requirements and complies with the rule of court 9.49. Lastly, if any conditions change, that is, a PLL is no longer working under the supervising lawyer, the State Bar needs to be notified within 10 days. So some of the questions we've been getting also are, how do we apply for the program? The applicants need to apply through the admissions applicant portal, that is through the AIM system. We have an FAQ on our website that has a link to that portal, as well as other information that may not be addressed in the instructions. And we constantly update that FAQ as needed. Applicants will also need to register with the Office of Admissions initially either as a student applicant or attorney applicant, because this is open to any attorney applicants who have graduated perhaps from an LLM program in that same time frame. And also, law school graduates will need to provide official sealed transcripts. And for clarity, if anyone has ever been eligible to sit for a bar exam, we already have that transcript. You don't need to resubmit it. If we have a copy of that in-house, that's already, this applicant has already met that requirement. Applicants must submit a declaration for each supervising lawyer. And there are cases that somebody might have more than one supervising lawyer. They must also accept the conditions noted in the applicant declaration, which is again in the application itself, and pay the corresponding fees. Also, once an applicant is approved, they must complete the State Bar New Attorney Training Program within the first 12 months of provisional licensure. One thing that we've also set up in the same way that we provide licensees on our public website is the ability to search whether somebody has been provisionally licensed or not. You can find that under our special admissions webpage under provisionally licensed lawyers. And just to give you a sense of how we have been accepting applications, it's been a very popular program. On our first day of launch, we accepted 421 applications in the system in the first 24 hours, and 33 were approved by the end of that day. Yesterday, we had about 835 applications, of which 387 were approved. And our statistics are just as strong this morning. We had about 847 in and one extra, 388 approved. There are discussions in terms of expanding this program. So a working group that was established to design the parameters of the program continue to meet to discuss other considerations. There are two large ones, and one of them is that we give consideration to exam applicants that scored at least a 1390, which is the new bar exam passing score on previous examinations. So the proposal on the table is that we open that up for anyone who's taken a bar exam from July 2017 and onward. So anybody who scored a 1390 from starting with bar exam July 2017 to present time would be eligible under this proposal. And also that applicants should be admitted to the state bar without needing to take another bar exam, as long as a certain set of supervised hours are met successfully under the PLP. So this is up for discussion at this working group, and will be presented to the Supreme Court for consideration. So with that, I'm wondering, does anybody have any questions? All right.
I actually would have a question. I'm struggling to find my hand to raise.
Okay.
But I was wondering about the parameters of the program. You said it's supposed to end in 2022. If this proves highly successful, would it possibly be extended beyond that? Is there any possibility this could become a permanent route to a license?
That has been raised in the past, and it's really up to the Supreme Court to make that determination. So, you know, in the working group discussions, we've raised that to them, and it's something that they're considering as well. So it's not off the table.
A follow-up, is there then any plan to do a study on provisionally licensed attorneys under the program to see whether the program is effective, for example, by looking at whether there are disciplinary actions, an inordinate number of disciplinary actions, or other indicators of poor lawyering among the provisionally licensed attorneys?
We have data that we'll be collecting as part of this effort, compliance being one of them. Also, if you look at the proposal in regards to the supervision of hours, one of the admission without a license, that is, that is admission based on a successful completion of a certain amount of hours. That also would include within that proposal an evaluation conducted by the supervising lawyer. So all of that information could help with an evaluation effort, and it is something that we could bring back to the working group. So that's a good suggestion. Sure.
I have a quick follow-up question, Amy. When you mentioned the numbers of applications and the numbers that have been approved, could I clarify what are the rest? I'm assuming that the remaining are in process, not that they have been denied. Can I clarify what the process is for an applicant who applies? I mean, how are they notified if it's pending or denied, or if they've made an error or missing some materials?
Oh, yes. So we have tried to automate this as much as possible. We have dedicated staff that are reviewing these applications. So you're right. Some of these, the ones that are outstanding within these numbers, for example, of the 835, we have 387 that are approved. We have a few denials within that, and our denial rate is fairly low. And the denials consist primarily of folks who either don't have a supervising lawyer assigned, or who don't meet the eligibility criteria, perhaps graduated at another time. And that may have happened because the proposal to expand the eligibility criteria has been out for a while, and I think people assumed that it was already in progress. But also we have, for example, applications where some aspect might be outstanding, perhaps a transcript, or the moral character application itself. I think one of the things that students need clarity on is the fact that the application has to be in a pending review status. If you look at the Ames portal, some people assume like if an application is submitted, but submitted does not necessarily mean that the application has been received and it's ready for review on our part, pending like an internal review. It really needs, the category needs to be pending internal review if it has not been cleared yet. So I think that is one of the areas where we have some of these pending applications.
And just to clarify also on that potential expansion group who does appear to be applying a little prematurely, should we tell them to wait? I mean, should they be discouraged, or should they go ahead and put the application in hoping that it will be approved, or are they going to have to start over because they're being denied for a premature application?
Yes, I think they should wait. It also allows us to give priority to those that are eligible. And so, and the logic has not been built into the system. So it would be beneficial to wait until that has happened.
Do we have any other questions about the provisional licensing?
Hi, Susan, I have a question. I was wondering if the State Bar will be sharing information with law schools about alums with approved applications.
So do you mean like specific names, or do you mean information about how to do this? Because we're meeting with the registrars next week, and we'll probably be covering the same process and information as to the requirements and the documentation.
No, I meant more specifically with the law schools, if we have alums who were approved for this provisional licensure.
I'm not aware that we are planning that.
Okay.
Amy, but there is a public list available that
There is
searchable.
Yes, so let me show you, and I can do that now. So give me 1 second. I will go into the system and show you what that search capacity looks like. 1 second. Okay, 1 minute. My VPN is having issues. Here we go. So let me share my screen. So I would need, here we go. All right. So as I mentioned, if you go to our website, you look under special admissions. Oops, sorry. I don't know how that happened. So let's go to admissions, special admissions. Under here, you have the provisionally licensed lawyers. And here's our search tool. And much like you can do with licensees, you can go in here and look either under the name of the student, of the applicant, the supervisor, or if you know their license number. So I'm gonna just, I know this, I don't know this person, I know I'm familiar with the name. I'm gonna look up, this is somebody who was approved very early on. And so yeah, as you can see here, this displays this is equivalent to a license number, their provisionally licensed lawyer number, when they became active, who the supervising attorney is, the law office that they work at, and contact email information. As well as for the supervising attorney, this is information from the licensee database. So yes, so in terms of Nadia, your question about looking at alums, this might be a method for doing that. You would just need you know, to know how to look for that person.
I have a question as well. What is the turnaround time from when someone's application is complete, all of their materials are in, and the approval? What's the time period?
It's very quick. So it's really contingent on how you know, how complete somebody's application is. So if somebody's moral character application has already been in line, as I mentioned, if they've already applied for a previous exam, whether it's a first year exam, whether it's the bar exam, you know, the turnaround time could be 1 day. I mean, we've had some that happen on the same day.
Thank you.
Sure.
Additional
right.
questions on the provisional license? Thank you, Amy. And in particular, thank you that the turnaround time is 1 day for some that have done it correctly. That's amazing. All right, our next update then is on bar exam deadlines, and I'd like to ask Audrey Ching to give us an update on that, please.
Good morning. I'm Audrey Ching, the Assistant Director of Admissions. And before I get into telling you about all these deadlines, so we opened the applications for the February bar exam actually on October 1st, which because of the quirk of the postponement of the bar exam was actually before the October bar exam, a few days before we even had that exam. So since then we have 2,121 applicants for the February bar exam. That was as of yesterday. On November 19th, we got the direction from the Supreme Court that the February exam will be remote, similar to how we conducted the October exam. So just wanted to give you some highlights before getting into these dates. And all of these dates are published on the website. If you go to the February 2021 exam, you'll see all these important dates. We also just posted an FAQ for the February exam, updating a lot of information about the remote exam. This week, we're also sending, since we had that direction from the Supreme Court, we're sending all the current applicants the acknowledgement and acceptance of testing conditions so they know what the remote exam will be like and they can agree to the remote exam, or if they want to withdraw, they can withdraw. And then we'll send that on a regular cadence to people as they keep applying. So speaking of applying, the final filing deadline is January 4th. As you can see, there's like all our exams, there's a staggered withdrawal deadline when they get different amounts of refunds back to them. So right now, we're going to be back in that 30% refund range, and then up until February 9th, you can withdraw, but without any refund at all. So for immediate repeaters, so again, we have sort of a very different time frame since we had an October bar exam. We actually are opening up the application for October bar exam folks on January 2nd. So even before results are released, they can apply, and then they will have 10 business days after the release of the results to timely file. So if they want to apply ahead of time and feel like even before results are released, they want to apply for the exam, they can early, and then they can, of course, if they get their results in the middle of January and want to withdraw because they passed, they can withdraw.
Audrey, just a quick follow-up
Yes.
question. Do they have to pay the fee to do that?
They will have to pay the fee to do that. They will get, if they pass, and they will get all their fees refunded back to them. So they will be able to withdraw if they did pass. But I just know there's been, at least from what's been expressed to us in, our email queue, some folks who really want to apply before getting those results because of timing. The next slide. So the final filing deadline is January 4th. And that's again for folks who are not repeaters. Obviously, if we're opening up applications for January 2nd for repeaters, and we're going to have a different final filing for them. It's on the website. All the different testing accommodation deadlines are there. If you know any applicants who are filing for that, there's a final filing deadline for their final petitions, the same as the final filing deadline of January 4th, their appeals, and then emergency testing accommodations is something emergency, someone, breaks an arm or whatever might constitute an emergency for a test. They might want to file an emergency petition. That's February 12th. Again, we're sending out that acknowledgement and acceptance of testing conditions to all the folks who have already applied this week. It's not due till January 15th because we're giving it, a lot of time ahead of time for them to read through it. And then of course we're sending it out on a cadence to everyone who keeps applying between now and then. The next slide. Just, actually what I'm thinking about the acknowledgement, if you can encourage everyone you might know who's applying for the February bar exam to whitelist emails from the bar. So calbar.ca.gov, we have the applicant's preferred email address on file, and we've told them to whitelist emails from us, but we are making a lot of changes. Obviously, we learned a lot from the October exam to put a lot of these deadlines out on our website ahead of time, but also we know that a lot of communication that we gave out to applicants for the October exam, there were some things that ended up in their spam or junk mail filters. So hopefully if we put all these deadlines ahead of time and get the message out to please either whitelist emails from us or make sure you check your spam and junk mail. That's just my own public service announcement. If you can put that out there to applicants as well. So we'll have the same mock exam process so they can practice not only the features of the exam, but also practice with old questions from past California bar exams. We'll have the first mock exam available January 26th. That's the same day we're doing their admittance tickets. Obviously, they don't need physical tickets for the remote exam, but they will get the approval that they've been admitted on that same day. Other highlights, so we'll have 2 mock exams, we'll have the exam files to download, and we'll go over this process, have weekly emails again to applicants starting in January. After the exam itself, they have standard applicants will have until the next day, February 25th at noon, to upload their answer files and their video proctoring files. And then of course, if they are on extended time or extended days, they have a different set of deadlines to upload because they're testing over a longer period. Is the next slide also mine? I don't remember. Oh, now actually that's back to Amy.
That's
So
our next slide.
Sorry. Any questions about the February exam, the remote exam? I know.
Audrey, just one question, and I'm not sure if you're the right person to ask, but do we have an exact date for release of results for October so that we know when they will be receiving that information?
So we're still, as we put out, we're trying to expedite to be able to release as soon as possible. So the published time frame is mid-January, but we're with our grading team trying to get those results released earlier than that. So unfortunately, I don't have we had the published answer is mid-January, but we are trying to expedite. Obviously, it's of great interest to everyone who took the October bar exam to get those results out more quickly, and that is what we're endeavoring to do. The very latest we'll have them out is the middle of January.
Assuming there is an earlier release date, is there a way that schools will be notified?
that we're going to release early.
Mhm.
Yes, I will. If we don't have that on the roadmap for release, then I will personally make sure we send all the deans that we are sending out the release early. That's a great idea.
Does anyone have questions for Audrey about the February exam deadline dates?
I have a question about the sort of turnaround for people who don't pass in October. It seems like they have to very quickly make a decision about if they're going to repeat in February. Has there been a conversation about either giving them more time to make that decision or to affirmatively decide and then later withdraw without financial penalty, like without them feeling like they're sort of being penalized from having to sort of deal with both October and now again potentially in February?
So like I said, we're opening it up earlier than we anticipate results being released. So having repeaters or potential repeaters being able to apply by January 2nd, and then they have, whenever we release the results, 10 business days after the release of the results to timely file. And then if they find out they pass, then they'll be able to withdraw with the refund. If they want to withdraw, even if they didn't pass, they'll get the 60% refund by February 9th. So those dates are all published on our website under the February 2021 bar exam. And we realize that the timing is not what it would be in a regular year, and we're trying to be flexible with opening up the application before people even have their results.
One clarification, Audrey, is when you mentioned that they can apply January 2nd, they do have to pay the fee, and then if they find out they passed, they can withdraw and receive a refund. Is there any advantage to doing that? I realize that in the old days you would be securing a seat, but is there any limitation on a remote exam that they need to secure a seat?
No, I think we were just being responsive to folks who said they really, they had a feeling about how they performed, and they really, right now they're barred from applying. They really want to apply and just know that they've applied and start studying.
Thank you.
Mhm.
Do we have any other questions on bar exam deadlines for February? This is a good place to take a break. Let's take a 5-minute break. My clock says it's 10:03. We'll come back at 10:08 and we will pick up with our next topic, which is bar exam survey results. Back so that we can resume. Currently, we've completed 2 of our staff updates on the provisional licensing program and the bar exam deadlines. And our next matter is the bar exam student survey, which I have as both Amy Nunez and Audrey Ching. So if either of you would like to give us a quick review of the bar exam student survey, that's our next matter.
All right, I will cover this for us. All right, so after the bar exam, a post-exam survey was sent to those examinees who took the exam online. As you may recall, in June, the State Bar developed a post-exam survey for examinees sitting for the first-year law student exam. And this survey was modeled after that one. However, we worked with the NCBE to design a survey that elicited information about a variety of topics. We learned from the first year exam and applied some of those lessons to what we needed to really hone in on for our bar exam takers. And so we asked about a range of topics, including people's familiarity with online examinations, the steps that they took to prepare for the exam, their assessment of the utility of instructional materials developed to assist with the remote administration, concerns about the remote administration, and challenges that they experience with the specific components of the remote exam, technology, location, the utility of the mock exam, and response time from help desk support. The goal, again, was to gather as much information to improve the remote testing experience for future exams. So The survey was sent to all 9,615 examinees who registered for the remote exam, and more than half provided a response, which yielded a 55% response rate. Now, in our process, we learned that it's clear test takers were under extraordinary stress for this administration of the exam. The pressure of the pandemic and the short timeline available to adjust and prepare for a remote exam were reflected in the number of survey results. For example, almost 6 out of 10 respondents expressed moderate or extreme concern over having to take an exam in any manner during the pandemic. However, despite this anxiety, when asked how they would prefer to take the bar exam if they had to sit for it again, respondents reported as follows. As you can see here, 63% preferred taking it online in an isolated environment, like at a hotel or at home. 25% preferred taking it on a computer in a group setting, such as a school or a test center. And only 6% reported preference for taking the exam in some other fashion other than a computer as an in-person exam. Also, over half, 57% reported that they were satisfied with remote testing, and 28% reported some level of dissatisfaction with remote testing. Can we go to the next slide, please? We were very interested in the technical issues that people experienced. On the day of the exam, about 1 in 5, that is 22% of respondents, reported having technical issues with the mock exam. Of those, more than half reported that it took them more than 45 minutes to resolve technical issues during the mock exam. And just as a background, the mock exam was required in order for somebody to take the online exam. And what the mock exam did is mimic all of the experiences for the bar exam. This includes accessing the password, accessing the implementation and use of that password, the features of the questions once you got in, whether it was a multiple choice question, an essay question, or a performance test question. So people could also practice with the features within the system, such as highlighting and zooming the screen in terms of the font size. And one of the assumptions too is that if somebody completes a mock exam and successfully, that it will lead to a successful bar exam experience. And that could have been the case since on the day of the exam, only 15% of respondents reporting having technical issues. And this is where we really want to focus. ExamSoft figures indicate that the company was contacted by just over 8% of exam takers, which is still a large number given the number of people signed up for the exam, and that the company was able to successfully resolve over 80% of these inquiries. So the State Bar is using this data to look at methods for improving, and there are 3 areas that we really want to focus on. One is instruction material, that is providing more greater clarity, because that was one of the reports that and findings that we received. The timeliness of instructions, and that has already happened and started to happen. So as Audrey noted in the presentation right before this, in terms of the timelines, the testing conditions and the acknowledgement and information sharing around that has already started. We had very little time from the time that the Supreme Court determined that we were going to move to a remote exam, and by the time that the exam happened. And so we now have more time, and we're hoping that the testing conditions is a way of starting the instruction process for taking the remote exam, what is anticipated from a student. And lastly, we also want to ensure that the ExamSoft features that are going to be available for the bar exam are available in the mock exam, and that will definitely help applicants during the exam administration. And there's more data that we're going to be developing as a summary of findings, and that we'll be publishing on our website. So there's more to come because it is a rich data source. Any questions?
Dawn? I think you're muted, Don.
Still doing that after all this time. So I have been surprised at how many concerns I've heard from current 3Ls about the potential for cheating on the bar exam. I'm sorry to say that, but there is some concern about that. Is there any attempt to monitor that beyond using ExamSoft to lock down computers?
So there are some protocols that we've implemented to reduce the potential for cheating. For example, the requirement that everybody use a laptop and not a desktop helps because it's a method for eliminating the potential use of external systems. But also in the review process, where the State Bar is not strictly relying on the ExamSoft system, we're also conducting manual reviews internally for cheating incidents. And so, we're hoping that helps, and we're in the process of doing that right now for the October 2020 exam.
What exactly does that entail? I don't know much about that.
So we look at the flagged videos. So anybody that was flagged by the ExamSoft, both the artificial intelligence, and then also there was human proctor review on the part of ExamSoft. Those flags came to the State Bar, and our staff, and along with proctors, are reviewing these videos to determine whether a Chapter 6 violation should be issued, a notice of violation should be issued to applicants. And so it's a variety of levels of review, and it means we're taking the protocols that we use for the bar exam and looking at the flags that we receive from the ExamSoft in order to make that determination.
Interesting. Do you have any data on the number of serious issues? The number
We don't.
of cheating fines?
Yeah, we are in the middle of this process right now. We're hoping to have this wrapped up. We're in December this month, obviously, before exam results are released. So we don't have data at the moment. We're still in the processing stage.
Thank you.
Sure.
Amy, could I confirm something about the process a little bit? So is it my understanding then that if a student has, if an applicant has received a flag either by the AI or by a human proctor, are they notified by email that they are under review, or is all of the review of your office happening without them even knowing?
Yes, so the only time that an applicant is aware of an incident is if a Chapter 6 violation is confirmed and they receive the issuance of that notice of violation. So no, there is on the part of the applicant, they're not made aware.
So the internal review process is done completely at the State Bar level, and then the applicants are only involved at the point at which it becomes there has been some sort of misconduct.
Yes. Mm-hmm.
And again, just to confirm, that's due to be wrapped up end of this month?
Yes. And also, when an applicant receives a Chapter 6 notice, you look at our admissions rules. If that violation is a disputable violation, they have some time to appeal that. But if it's an indisputable violation, they cannot. And so an example of an indisputable violation is, for example, bringing a cell phone into the room or having one during the exam as an example. Electronic devices are primarily indisputable offenses.
Just to confirm, I know one of the things that I heard a lot from students, and I assume others did as well, is the students were very worried about technical violations. For example, a door opened in a hotel room, or a door opened and closed and nothing got said and nothing got done. And I'm assuming that this is going to result in at least an AI flag and possibly a human flag. Can you give us any sense of how those type of more not the serious cheating that Dawn's mentioning, but something far more innocuous, an open and closed door. How does that get handled under this process?
Yeah, I mean, these incidents happen. And so if you look at what our testing conditions specified, people needed to remain in front of the camera and no one else could be in the room. So door opening is not necessarily somebody being in the room. So sometimes, you know, an incident like that would be a matter of one of our reviewers reviewing that and noticing that there was little to no interference with the applicant's exam taking session. And so that could be merely, you know, it would be acknowledged by our staff and may not lead to a sanction unless something else was noted, perhaps somebody talking to them or something like that. But if there was no disruption, that shouldn't be a problem. What we really wanted to do is have a very minimal disruption and potential for cheating to that applicant. So, you know, we aspire for people to have a very isolated testing environment.
I follow up on that topic. I know a lot of the students I worked with, they were very like paranoid, to put it lightly, about those kind of issues, not the cheating issues, but the, oh my God, there was a noise in my room. And one of the things that may be helpful heading into February and however long the exam is being administered this way is for the bar, as a part of the FAQ document or sort of some other guidance, to sort of say, hey, here are specifically some things that we typically don't think are real issues. You would be surprised how many times I had to tell folks that I didn't think the bar was going to penalize them because their dog barked. And, you know, none of the things on the website actually addressed those things. And so they went to a very fatalistic point of view. And it would be much easier if the bar was more clear about some of those things, like someone opens the door and accidentally shuts it. Like, that's probably not an issue.
Yes, that's a good point, Devin. And yes, we are aware, because after the exam, we received multiple questions about and concerns about some of these incidents. And again, what we want to do is we wanted to be flexible and allow as many people to test from home as possible. But also we need to uphold our exam security standards and ensure that you know, minimize any potential for cheating. So that's really what we're using as a guideline as we review these videos is, you know, what could be a potential cheating incident is recognized, and then also and discerning between that and some accidental issues such as a dog barking. Yeah, that cannot be a cheating incident. And like I said, things happen, you know, even with certain sound issues. I think what we're doing is, and that's why this review is so intensive and takes a while, is just ensuring that we're not hearing, like, for example, another person speaking in the room or whatever the case might be. But a dog barking is certainly, you know, something that we wanted to deter, but sometimes things happen, you know, accidents happen, doors open. You're in a household. We recognize that people are living together. And this is why also we reached out to the schools and also allowed students or applicants who had extenuating circumstances the ability to test in person as well. So yeah, we're putting all of that together.
Just want to say real quickly, Amy, too. So we received hundreds of emails after the exam with questions like that about someone walking in on accident or a dog, and I think what we're planning on doing, like I said, we already put out the FAQs for the February bar exam, but that we're going to draft some based on all the emails we received after the 2 days of testing in October, about after the exam, if this happened during the exam, like what will happen next. So I think that is, you know, we're trying to improve our communication a lot around what we learned from October and turn that around quickly, and that we're going to put together some more post-exam FAQs as well, because there were a lot of questions about uploading video files and time, you know, how much hard drive space or whatever might have happened after the exam. So we've already put out all the FAQs that we drafted for what's going on now with applying, and, you know, what the remote exam will be like and the mock exams, but we're going to put out after the exam FAQs as well.
If if I could ask one clarification on the slides, I noticed that one of your numbers there is that ExamSoft has indicated that 8% of takers contacted them. I heard complaints that folks couldn't get through to ExamSoft. Have we investigated at all? 8% is what got through. Have we been able to identify at all whether or not folks attempted to contact ExamSoft and were unable to be successful?
We have, so ExamSoft conducted their own analysis, and we have our analysis as well, and we're merging those together. But the other thing that ExamSoft uses is their call records. And so everybody that called gets logged into the system. What I don't know is whether somebody called and no one picked up, but I don't think ExamSoft had that kind of call. So if somebody called and reached ExamSoft, those are some of the statistics that they account for. So that is what's incorporated here.
Is that 8% California or all ExamSoft takers?
California.
Do we have
Amy?
other questions about, Donald, go ahead.
Oh, I'm sorry to interrupt you, Susan. Thank you. So Amy, let me ask, there was some articles in popular literature and also a study, I think out of NYU or Columbia, I can't remember, that seemed to suggest that the AI involved in the ExamSoft for the proctoring aspect of it had a disparate impact on people of color because of shadowing, et cetera. Is that something the bar considered or would consider, given maybe the population of folks that might be coming up as those who've been flagged as potential violators?
Well, we were aware of that. We actually received a lot of information about possibly the same studies that you're referring to. And we had the mock exam as one of our examples for to eliminate any potential for that, so that, for example, if somebody was going to take the exam and had concerns about that, the mock exam would be the process for potentially addressing whether it's a lighting issue or the process itself. But one of the things that we won't be able to address is did the AI happen to flag more people of color or not? The issue is that we have all our proctors have no information aside from, actually visibly seeing someone that is tracking that. We separate any demographic, personally identifying information from the video process itself. So that would be something that would be tough to gauge in our review process. It's not something that we're intending to do, but we are aware that of these concerns, and so
And there
we also required our proctors to do implicit bias training also as part of their the review process. Go ahead, Audrey. Sorry.
Oh, just that the identification process was deferred. So even if someone was trying to take the picture to match their baseline photo to get into an exam session and there was a flag that it wasn't matching, it didn't prohibit that applicant from getting into the session. So we deferred the ID process. So if there was some sort of mismatch, and then when we're reviewing the videos as staff later, we can either look at the picture that wasn't quite matching, or we also got their government ID in the mock exam process. So we can, manually as staff look at those photos as well. No one was barred entering into a session because of any ID matching problem.
On a related issue, have you collected data or done a study already yet on whether the online exam process generally has any effects on diverse socioeconomic groups or racial and ethnic groups? Are people from less advantaged socioeconomic circumstances more likely, for example, to have technical issues? Are they more likely to prefer having a conventional exam? I'm concerned primarily, I suppose, about the impact of resource requirements, having good equipment, having a space that is a little more isolated, not necessarily shared. Do we have data on that?
Well, this would be our data on that. So, and what I mean by that is, this is our first attempt with the bar exam. So, this is basically going to be our baseline information. And we did ask questions about people's testing environment, like whether they experience any technical difficulties, whether their testing environment impacted, various ways in their in the way that their testing environment could have impacted their testing experience. And so, again, this is the baseline establishment because it's the first bar exam that we do online, and that we also, it's our first post-exam survey. So this data can speak to that, and we're hoping to do that through this publication.
Amy, I did have one question. This is Chris Edegon from UC Davis. Going back to the statistics about the flags and the exemplify and the cases identified as cheating, the indisputable versus disputable, it might be helpful to see what those numbers look like. I've sat in on moral character presentations where we had some great presenters from the bar say, look, only this many people actually get flagged and only this many people go to an informal hearing. And we use those numbers to sort of calm the nerves of our students. So if there could be something similar in terms of, look, only this many people actually get flagged by Exemplify and only this many people were actually, I guess, written up, it might be a metric that I could share with, for example, my students who are very worried about being flagged and sort of calm their nerves.
Okay, that's helpful. Thank you.
To follow up on Chris's point, one thing that I think also could be helpful is I know some of us at the law schools, we provided space to those who didn't have the kinds of conditions and internet connections they required at home. And while that was possible in limited ways, the single room requirement is very tricky. And especially those of us at larger law schools, I managed this time, but I am anticipating that if I have a greater level of interest, I'm going to have trouble meeting that single room requirement. And I wonder if the bar might consider or look into, obviously all of the law schools have academic integrity systems. We have proctors. We have excellent abilities to administer our own exams and curtail cheating. We would love to be able to put a few people in a large room with a proctor, or with whatever would make the bar satisfied that it was not a compromised situation. Because obviously a large classroom that holds 120 people, if I could even put 5 people in there, it would be hugely helpful in accommodating, and I think addressing some of Don's concerns that I share, that there are a lot of folks at my school who do not have the equipment and connections that make them comfortable to take these remote exams at home.
Yeah, we did explore that, and the big issue is the potential flagging. We cannot control what the AI sees, so having a room, especially if a proctor is walking around as they should, watching people, observing people take the exam, would definitely create a flag. And so that's the that's the set of providing this space. I mean, early on when we were looking at the administration of this exam, we met with the schools, and this is exactly what they discussed. We provided space as well, and what we provided were individual rooms for applicants. And so, it's a challenging process, but it's part of the downside of artificial intelligence and not being able to control for that, and having anybody else within the screen will create flags for that student. And so it's just a balance that we're going to have to strike.
If the rooms were not proctored, would it be possible to have, would it be possible for ExamSoft to recognize that although there are multiple people in this room, if there's only a single person in the screen, is there a way that we could perhaps work with the software company to something other than single room?
Well, I mean, I think the other factor though is if somebody makes a sound, the disruption for everybody else's testing experience. I mean, we could put our heads together about doing this, but I think we also just need to recognize the logistics and some of the factors to consider in that process. Having that space, what the impact it might have on other people in this, other test takers in the same room. Perhaps, for example, if somebody has technical problems and needs to make a call, you have 4 other people in the room as well. So, there's a lot to weigh out in this process. So for the moment, and given that this was our first experience, and we didn't experience any of that, the individual rooms are really part of this requirement, or 1 individual per room.
To follow up on your point about technical issues, I noticed that you indicated it took more than 45 minutes to resolve most of the issues. That's an entire essay or half of a performance exam. Were students given additional time, or was there some sort of compensation for that?
What we did is we opened the accessibility of the question. So, for example, the password is available, let's say at 11:30, and it was supposed to shut off at 11:40. That time was extended to accommodate these students. So no one was allowed to get extra time. However, they were allowed extra access time. So it accommodated those students. As a matter of fact, I wanted to report a little bit about the numbers in the long run. For example, of the exam files that came back. So that is once somebody started and then they uploaded their file, we had 97.3% of exam files that were uploaded by essay question, for each essay question. So it was a success rate. We had very few instances of people that were unable to access a question due to that kind of time disruption.
And I think, go ahead, sorry.
I was just gonna say, does that time disruption then follow through the rest of the exam? So for example, if I've missed 45 minutes of essay 1, then everything for the exam becomes extended for me to access the rest of the remaining parts of the exam?
So yeah, so what I was going to say was that during the exam administration, we were in a Zoom with ExamSoft troubleshooting some of these issues in real time. So as calls either came into our call center at the bar or into ExamSoft, they could say, applicant so-and-so had these issues. Can we give them more time to finish essay 1, essay 2, whatever it was? And then yes, that would mean that they would need that kind of like daisy chain effect of additional time for the rest of that, at least that day if it was day 1, right? So we were able to troubleshoot like that and change what they call the remote assessment deletion time when we had those kind of notifications about folks that were in their queue getting their issues resolved but needing more time. And then yeah, if they need more time to get into one session, it kind of follows on that they would need more time for the other sessions that day.
Much like Chris's comment earlier, this would be information that would be helpful to put in an FAQ or share with students because it would alleviate concern. I think many students were operating under the misassumption that if I had technical problems, that is lost time. So if they understood that there would be a process and this was a little bit more, I mean, obviously everything gets a little more obvious when it's not the first time.
I had a follow-up question, if that's okay. Amy, you had mentioned in terms of, if there was a way, for example, to allow multiple test takers in one room with the Exemplify monitoring, that it, wouldn't pick up, right, the other individuals in the room. But you had mentioned that there were some considerations to be made, such as the distraction other test takers could make to one another. I'm just wondering how that's any different than the bar as it's normally administered, where you would be in a convention center with hundreds of people in a room. Is there a different consideration being made in trying to create a setting, perhaps at a law school, where we would have, as Susan mentioned, maybe even 5 test takers, right, in a space that we should be thinking about?
Yeah, I think that's the issue. If we had a space like that, the proctoring system, the online system would flag anybody that, for example, at a bar exam, a proctor, walks around the room, is observing, people answering any questions, and and some of that, all of that would be flagged if we went to in an online exam, in a remote exam experience, so that that is the problem that we're trying to figure out how to address is, how do we do that without raising that many, flags, erroneous flags? Because it could be that somebody's just merely getting observed or having some issue addressed. It would recognize that as a potential cheating incident.
If a proctor was present,
Yes.
right, in that room, in that
Yeah.
option. Mhm.
To the system, it's another person,
Mhm.
whether they're, especially if they end up talking to that person, it's a flag.
Can I ask a follow-up question about, you said 97%, I believe you said were able to access the questions? Is that,
No.
can you restate that?
Sure,
data
sure, I'll
point?
repeat that. So when you look at the number of people who started the exam and the number of people who uploaded their exam files at the end after the exam. So that is, once the exam was over, they went home and the files had to get uploaded. And this includes the video file and their answer files. 97.3 successfully uploaded.
And how does that compare to a typical in-person exam?
It's much lower. The no-show rate at a typical in-person exam can be 5 or 6%.
Yeah.
So it was much lower than an in-person exam.
So we actually had more people seem to complete and get their files posted than is typical. That's what you're saying.
Correct.
Wow, I'm surprised by that.
Always nice to get a good surprise.
Amy, I'm sorry, I have another just follow-up question about the if we're permitted to try to create some space on our campuses, right, to have multiple students testing in a space. Would the state bar be willing to consider whether working with law schools to have a live proctor and not an online proctor for some of those, some of these administrations of the bar? Is that something that could be considered or explored?
No, we discussed this obviously for this exam. And one of the challenges that we had around that too was the fact that we also have to conform to local safety protocols given the COVID issues. And so the concern was, counties were moving from one, safety level to another. So people were moving into red categories so drastically that our concern was, what if we're preparing for all of this and the day of, we're not allowed to have more than 5 people or 10 people congregate? Because aside from having a proctor, we kind of need a team that, there's a team that goes along with a proctor, that is somebody who's working to hand out the exams and collect them, because we have to do that in a very, there's a methodology to that. And so, the concern was the number of people congregating in one area. And so, it's hard to plan for that. I mean, if we're going to remote, it really means that people need an isolated work environment and that there's no threat to the potential that might be canceled due to some of the COVID restrictions. And so, we did consider it, but I think that is ultimately where we landed for those reasons.
Thank you.
Mm-hmm.
Can you talk a little bit about what the situation was like for people that got space offered by the bar? You said they were in individual hotel rooms. Was there a proctor in the room with, how did that work for those bar takers?
So we had rooms scheduled for testing accommodation applicants. The hotels set up across the state. And so applicants with extenuating circumstances, like we mentioned, people who perhaps didn't have either the technology or the space itself, were granted the ability to come on site, and they were each in an individual room. People had to adhere to safety protocols, and that is like wearing a mask throughout the examination experience. And then also there were proctors like in the hallway, and so people had their own room, but there were definitely proctors in that environment. Also, you know, for testing accommodation applicants, there were also proctors, so they were you know, treated like an on-site exam.
But there were not the concern about sort of the proctor disrupting the AI in that situation?
Well, they weren't in the room. Everybody had their individual room. So proctors were in the hallway. Everyone and staff and proctors were instructed not to disrupt an applicant while they were testing.
Thank you.
Mhm.
Thank you, Amy. That's really helpful. And I think I can safely speak for everyone that law schools are interested in trying to help make the process easier and trying to make the process more accessible to the most folks possible. So we really want to help be part of the solution, not just bringing up problems. But I also think I have to think ExamSoft can help us here somehow with some kinds of solutions and ways, if maybe they realized how very much we would like to be able to offer things in a wider setting, should we need to. Obviously, the public health protocols trump everything, and I think all of us were very good about communicating that to students in terms of saying, we're going to try to help, but subject to public health limitation.
Yes. You know, I think that's helpful, and you know, we'll probably regroup again just to figure out what we can do and where we're at also, as you mentioned, with our health protocols.
And February is going to be a good opportunity for us to try it perhaps in a smoother and smaller scenario. And that will get us ready for if July remains remote as well, which is of course, the larger and more concerning situation. We may have some time to try to work some solutions here.
Okay, great.
Did anybody else want to add anything additionally on the bar student survey, additional developments before we go into our next item, which is recent developments? All right, well, that was extremely helpful, Amy. Thank you again. And I want to turn it over to Natalie and ask her to talk about some recent developments on the bar exam strategies and stories program and access and inclusion. Natalie, I can't hear you.
Yeah, you're muted, Nat.
Here you go. That will make things much easier. Okay, I'm just going to share my screen while we're talking. Okay, so we'll be talking about three things that will be discussed in further detail at the Law School Assembly next week as well. The first of these is not exactly new, the Bar Exam Strategies and Stories program, but what is new is that this program will be available to February bar applicants for the first time. This is a program being conducted by an outside consortium of academic researchers designed to help students establish a productive mindset when they're studying for the exam. Right now, it's a free program. It takes about 45 minutes to complete, and it's helpful for the student to take this program as soon as they can in the studying process so they can very quickly adopt this productive mindset. On the 25th of November, students that had already applied for the bar exam received the first invitation to participate. If they had wanted to sign up, they should still have that in their email box if they want to become a part of this. And if they sign up by December 7th, then they will be in the first wave of the program. They will get access to this program in December and be able to complete it right away. If they decide that they would like to sign up after December 7th, then they'll receive the program in the second wave in January. This program has been offered for several July administrations, and with positive results so far. The researchers are doing research to determine whether the results are causal or correlated, but they've been happy with what they've seen so far. Many students are aware of this program, but not all. So we just wanted to make sure that all of you knew that this could be available to your February students. Are there any questions? Okay. I don't see any hands, so I'll move on to the second topic. This is actually more of a reminder. For the second time, our Office of Access and Inclusion has issued to all law school deans in California a survey on programs to improve retention of diverse law students. Some of you might remember that at the Law School Assembly last year, a couple of those programs were highlighted, one from Loyola and another from UC Hastings, their LEOP program. The Access and Inclusion Office is wanting to know more about what you are doing right now, not only to understand what's available to students, but also to eventually understand what sorts of support resources the State Bar may be able to make available as well. The original deadline was December, and about 60% of the schools have responded so far, but they really do want to hear from everyone. So today, law school deans at your school will be getting a reminder that the survey deadline has been extended to December 11th. And we really hope that you will be able to participate and that these results will be able to be shared in the next Law School Assembly in 2021. Any questions about this survey? Okay, and then just one more. This is a little bit of a preview. This is a developing issue. Many of you know about the Lawyer Assistance Program, and despite its name, it's available not only to lawyers, but also to law students and bar applicants. So we wanted to make you aware that the career transition resources that are available through the program are being briefed to understand the provisional license program. So if students contact this group, they will know about the PLL program and any opportunities that are available through that. And the LAP also reminds you that while many of the law schools already have a very well developed internal counseling function, that students who are experiencing stress or other adjustment issues related to the events of this year, the public health events, can contact the LAP. There are certain options that are available at no charge, including support groups and other possibilities. So we just want to make sure that you're aware of this information, and we will be bringing someone from the LAP to the Law School Assembly for a more detailed conversation next week. Any questions about these options that are just part of the offerings of the LAP? Okay, well, thank you. Those are the recent developments that I have for today.
And I'll just put in my personal note of thanks to Natalie for these updates, and also to say that my students have had some very great experiences finding LAP on their own. But thank you for reminding all of us that it's more widely available. It has been extremely helpful, and it's an excellent program.
Great, thank you.
Did anyone have any questions on the recent developments, whether it's bar exam strategies and stories, access and inclusion, or the LAP resources? Then we'll move to our business matters. Our business matters are the final part of our meeting today. And our first order of business is, I believe, since we do have a quorum, that we can approve the minutes. So if I could ask someone to please move for their approval, and then I'll ask for someone to second.
So moved.
Thank you. Let's see, it's a motion from Don Smythe to move approval of the minutes from the October 17th, 2019 meeting. Can I hear a second?
I'll second.
And that's Donald Scotton moving to second approval of the November 17th, 2019 minutes. Now, what I do not know, maybe Grant, you can assist me. Do we need to do a roll call, or can we just do a show of hands?
In fact, we do need to do a roll call because we are in a remote situation. For those of you that were not in attendance at the meeting, of course, you may abstain. And if we have fewer than a quorum participating, then we can note the approval, if not the adoption of the minutes.
Thank you, Natalie.
Would you like me to call the roll?
I can
Please.
call it.
Perfect.
Okay. Chair Susan Bakshin,
Vote yes to approve.
Nydia Dueñas. Oh, I'm sorry, I can't
I
hear.
think you're muted.
I'm abstaining.
Christopher Ide Don,
Abstain.
Devin Kenyon,
Abstained.
Jennifer Mnuchin, Donald Scotton,
I can't remember if I was there or not, so I think I'm gonna have to abstain.
Don Smith.
Approved.
Is there anyone that I missed? The motion passes, I believe.
Just to clarify, Donald, you were present. You're noted present in the minutes.
Thank you. Thank you.
All right, thank you. And I appreciate the technical assistance. And our next order of business is actually a quick update from Natalie on the allocation list procedures. And for everyone, I'm sure in this group is familiar, the allocation list is sent to law schools to advise us about who will be taking the bar exam. And Natalie has some tips for us today to avoid back-end problems of finding someone on your pass-fail list who did not belong there. So I'm going to ask her to give us an update on the allocation list.
Okay, thank you. And I'm going to share my screen with you again. Okay, so this is something we generally do with registrars. So some of you may have seen this or may not have. And in preparing for this meeting, we learned that it might be helpful for other administrators at large to know a little bit more about this process and know how this can help us to help you by issuing correct pass-fail lists as soon as possible. So in getting ready for the bar exam, there are a couple of ways in which the State Bar contacts your registrar. The first one most people know about that has to do with the certification list. We reach out to the schools and we ask for proof that the student has completed the educational requirements prior to taking the bar exam, either through generally providing a transcript or in some cases, getting a representation from the school if they've finished their work very close to the exam, and then getting conditional approval until that transcript is received. The lesser known but extremely important process is taking a look at the preliminary allocation list. So this is a list that we create prior to the exam. We send it to the registrars about a week before, and it includes a list of everyone who is allocated to your law school, and we'll talk about what allocation means in just a moment. So at that time, it would include your alumni as well as your current students that are approved to take the exam. We ask you to respond as soon as possible, but certainly no later than 4 weeks after the exam. After the exam happens, you get a second list, the final allocation list. So that should be a subset of the preliminary allocation list. If 10 students were scheduled to take the bar exam, but only 8 did come to take it, your second list should be smaller, never larger. But as a result, many people wait until that final allocation list time, which we can handle, but it's extremely helpful to us if you actually review the list beforehand. And why would you review this list? What sorts of things could come up? Well, first of all, sometimes in particular with transfer students, they may not have noted their transfer properly, or there may be confusion when a student has attended more than one law school. So for example, they may have attended one law school for a JD, another for an LLM program, perhaps even an additional law school for a tax program, and they may actually themselves apply the incorrect law school for the purposes of qualifying for the bar exam. So if I've attended one school for my JD and 2 more for master's, it's ultimately the JD that will qualify me for the bar exam. And so I'll just show you a little bit of a slide that will explain how we allocate the students. Oops, we're experiencing technical difficulties. Okay, can everyone see this page?
I cannot.
I don't see anything, Nat.
Okay, just a second. Thanks for your patience.
We can see it now, Natalie.
Okay, great, thank you. So the students that you should expect to see on your list are your JD graduates that are not yet licensed in any other jurisdiction. You may have other students that have attended your school that won't be on this list by design. So you won't have JD graduates from your school who are already licensed in another state. Those students will be allocated as attorneys, eligible to take the attorney exam. Graduates who earned a first degree in law elsewhere. So occasionally we see people that have been educated outside the United States, but then they choose an additional US JD program, and they generally qualify on their first. Applicants who take the bar exam under the 4-year rule. So that's a situation in which a student may not have a JD degree, but may have completed 4 years of study under a very specific set of circumstance. And if a student is interested in that, they can contact eligibility to learn the exact details of that very specific program. Or finally, your students in your master's programs, your LLM programs would not be on this list. But you might occasionally see an errant person, someone who was previously at your school, since transferred out, or someone who didn't start at your school, but finished their JD program there. And so I will just make a plug to encourage all of you to have your registrars take a look at the preliminary allocation list that's sent by Patty Salazar about a week before the exam. It's one less thing for the State Bar to have to look at and go back and forth with you. If we've got that information up front. And some of you might have had the experience where we issue a pass-fail list to you, and each student's individual pass-fail result is correct, but you might say, hey, where is the student, or why is that student on my list? And that comes from allocation discussions that we're always hoping to have before the exam if we can. Has anyone had experience with this process before? Is this something you're seeing for the first time?
Yes, really. I oversee the registrar's office at Southwestern, so I have had experience with this. And I had a question, but if it's better suited for the registrar's meeting, I'm happy to postpone it to that time. But annually, one of the issues that we experience is that we receive the preliminary allocation list from the bar, but there are students of ours that are missing from that list. So in past years, our process has been that we would like manually add those students, right, that we know we have certified and that are eligible to take the exam to that list so that they can, be added. And it appears this year that was not the process that they wanted. They didn't want us to add those additional or include any additional students on that list that they did not have. But what that causes on our end is we get a lot of students who notify us that they've been contacted by the bar that they've not yet been certified to sit for the bar exam. So they, are obviously extremely stressed out by that while they're studying for the bar. So I don't know if there's any processing way to resolve that I'm not aware of, or if there's any particular process that I could share with my registrar to ensure that we are providing the bar if the list they get back to us does not match our certification list, that we know how to get those students on that list so that they don't receive those communications while they're studying for the bar exam.
Okay, that brings up a couple of thoughts. Offline, we can look at some particular students, if you recall one or two, and we can determine whether they would normally be on the list or not. If they're not normally on the list, but you need that information, we can see what options might be available for them. Another thing to be aware of is that right now in the AIMS portal, which is still relatively new in the applicant portal, the students do see a message until we contact the school to request the certification that that portion of their application is incomplete. And from time to time, students might be stressed or worried or contact the registrar's office regarding that. And so we could look to see what options there might be to make it very clear that that's a request that we do from the school on a scheduled time. And perhaps that could help address concerns as well.
Okay, thank you.
Just to note, I would agree that it would be helpful if the AIMS portal did differentiate what was being expected from the law school versus expected from the applicant, because I field a few hundred calls a year on where it says I'm not certified, can I not take? And I believe it is nothing other than the stress of taking the exam and feeling like something is incomplete. But if the portal has been otherwise so very helpful in the students knowing where they are in the process and what's needed from them, but if we could just put a flag that says this is coming from your law school, not you, I think that would be very helpful in terms of, and of course we can, I agree with Nydia, probably at the registrar's meeting, the details of this, I'm sure they'll have some ideas as well.
Mm-hmm. Okay.
Did anyone have
There any other-
additional questions on the allocation list or processes? Again, this is like most of today's meeting. This is something we very much will have more details at the registrar's meeting, which is Thursday, December 10th at 9:30, and also the law school assembly at 1 o'clock on that same day, December 10th. All right, our last topic is just that. If anyone has anything that you would like us to consider for, that you have comments you'd like to pass on to the bar examiners about, or to the state bar, sorry, about the registrar's meeting or the law school assembly, if there's anything we've touched on today that you feel would be something to consider. Obviously, it's short notice. These meetings have all been rescheduled via the pandemic. But if you have anything you'd like to share, this is a good opportunity for sharing any kind of comments you have, or if you feel like today's discussion has been a good lead in. I think we've given the bar a lot of good ideas and feedback so far about what the school's concerns are. Did anybody want to add anything? All right, unless Natalie tells me that I have forgotten something, I believe we have accomplished all of the official business on the agenda, and that you have 20 minutes of your day back to do with as you please. If anybody has a final comment, you're obviously welcome to send those along to me or to Natalie at your convenience. Otherwise, I so appreciate your attendance today, your comments today, and I so appreciate the bar's willingness to involve law schools in the process.
Thank you, everyone.
Thank you.
We'll
Thanks for-
adjourn. Thank
Have a
you.